Lordship, more than 1 year, this matter has not come out.
Oh,
It was last listed on March 2023 for motion,
all right,
Lordship.
then let it be on 29th.
Kindly tomorrow, Lordship.
Why? It has not been listed for 1 year. We are giving you the earliest possible date.
So
Monday.
actually, this matter relates to compensation payment for land acquisition.
That's
So,
right. We'll
yes,
hear it on Monday.
Monday.
Coming Monday, 29th. Sorry, not 29th. 24th. 24th.
Actually, Lordship, yesterday my client through telephonic, she informed me that some person came. I don't know whether it's respondent side or not. No, some person came to her house and told her to inform her that they are going to demolish their house. Lordship. That's why it's a little bit urgent
The 22nd.
in
not
this
your-
second.
May it please, Your Lordship. Item number 6, my lord. I had filed my affidavit on 16th, my lord. So record may be kindly called for.
Back to mention item number 8, Lordship, daily list. But the matter come on next week, Lordship. I will inform the other side.
Item 8 will be listed as a part 2 hearing. Yes, next part 2 hearing. Yes,
May I please, Your Lordship. Lordship, I pray for listing a matter for withdrawal
tomorrow.
tomorrow. If you-
Please, Your Lordship. Item number 59 of part 2 hearing list, Lordship.
59.
59. Lordship, kindly adjourn it for 2 weeks.
Why 2 weeks? We will not follow up this week. Next week, get ready. Item 59.
I beg to mention for listing of a contempt petition, Lordship, which was filed on the day before yesterday, Lordship.
They will come
So
on its
kindly-
own.
Kindly list.
So it will come on its own. Why are you making a mention fresh matter? If the
Lordship, it's an
details are clear, it will come on its own.
urgency. It's an urgency, Lordship.
On time matter.
Oh, yes.
What urgency?
Lordship, who directed to settle the main mahal.
That's right. We'll examine it. Let it come on its own. If it doesn't get listed for weeks together, you make a mention. It'll come on its own.
Worship can be just worship's last order, my God. That's arbitration.
Yes.
Lordship, may peruse my instruction. As per my instruction, Lordship, they have not received the representation dated 28/6/2024 as submitted by the petitioner.
Pending next week. No? One of the-
You have not submitted documents before the Kala.
It's there, my online.
Hmm?
We
You show
submitted-
the instructions there.
We submitted, my. Oh.
Madam, you show the instructions.
Hmm?
Notice issue করা হবে স্যার। Notice issue করা হবে স্যার। Release করবো।
मैं तो वही अमाउंट का मैंने सब करवाया था को भी बने that amount which is disputed our question, madam, since we are not agreeable to that amount, we submitted that let it be decided, madam.
All right. We are disposing it of, directing the Kala
That,
to
yes.
refer it to arbitration. in terms of
No,
three, what is 3H5?
3G7,
3G7.
huh? Yes,
3G5
five, but
worship.
3G5.
3G5.
National Highway.
I'm, no, it is, এখানে লইলো। আছে নাকি না? নাই। 5 graded 7, my dear.
3H4.
3,
3.
3G5.
Huh?
3G5 and 7 yellows. Five and 7.
No, you have filed before the arbitrator.
Yes, yes.
3G5. Is there a dispute with regard to the share of the compensation?
No, no, no.
Only the
Only
quantum?
The
amount.
amount.
Building, Jirat and other things. that is.
Heard Mr. H.R. Chaudhary. Learned counsel for the commissioner.
তোমার চাইতো।
The
তো তোমাদের তোমার petition দাও। তুমি তো
uh,
লেখা নাই নাকি?
the Hazarika appearing for the director of department. Arbora for NHITCL. Mr. Sharma for state. Column 5 and 6. The petitioner is agreed
Representation.
by petitioner as approached the scope. What is the amount decided here
Oh,
by the
2 crore.
Tala?
তাহলে কিমান amount কিমান দিছে?
I don't know. 2 crore, Lordship.
Is agreed by the fact that Yes.
Compensation amount is 168,
53.
90.
What can you keep my communication?
168, 5,
This is compensation fees for land as well as the building
Along with Jirat also.
along with that. The petitioner is agreed that for construction of national highway roads
Total
The
2
land.
2 crore.
belonging to the petitioner along with the building have been acquired by the competent authority, by the
Yeah.
notification dated 18/12/21.
for the purposes of safe construction.
No.
Total compensation of rupees 1 comma, what is the amount?
1 crore,
One,
68 lakhs, 53,096.
168.53
53.
096.
has been determined as a compensation along with compensation for the land and the building along with the petitioner is agreed with the quantification of its compensation amount. Stop according to the petitioner, the RCC building, which is three-storied RCC building, which is used for commercial purposes, and the land is valued together, should be more than 5 acres. And the land measuring 3 bighas is required to be valued rupees 12 crores, 12 lakhs. You are seeking valuation of the land at 12 lakhs as per the prayer in the writ petition.
no, yes, my, that is my, at the rate, my land.
No, is it for
Total my assessment, I got it as a 5,39 lakhs 48,900. This is our calculation.
so 12 crore is for 3 bighas of land.
Yes, no?
12 crore, 3 bighas of land, and the total value, total compensation came the 539, 48, 937. So, along with interest paid. That having not been paid, petitioner is making an direct NHIDCL has settled the matter by their affidavit and admitted that the amount assessed has already been deposited with the competent authority, namely the responsible by. Therefore, under the provision of the National Highway Act, the petitioner is quite approach the competent authority. And in the event the compensation amount estimated is not agreeable to the petitioner, that there are steps provided under the provision of the NHIA Act. Ventilate the grievances raised with the so the during the course of the hearing, the respondent counsel appearing for the revenue department, the government counsel representing the competent or namely the additional were permitted opportunities to pay their. The government counsel and the standing counsel of the revenue department submitted to the court that the amount assessed is lying with the competent authority and the same could not be released to the petitioner because of non-furnishing of the relevant and adequate documents sought for by the petitioner. Whereas learned senior counsel on the other hand submits that in terms of the provisions of 3H, 3G, 3G, 3 capital G, within bracket 5, the amount determined by the competent authority was not acceptable to the petitioner. Therefore, she has filed an application before the competent authority, who has, however, failed to take necessary steps in the as mandated under the Act. Such submissions. What are your instructions with regard to that? Whether they have filed a representation?
Whether the department has received the representation filed by the petitioner lordship. But as per my instruction, the representation has not been received by the department till date, lordship.
Not received.
Not received. Lordship may peruse my instruction.
My ID, you have given that. Acknowledgement is there for an online or business.
When I put the paper, I think it's not. I probably consider
How is it to be submitted? Online or physical?
online.
They have submitted online.
Online, the response is also there, madam. They received also, that is there.
Physically, they can submit lordship.
Hmm?
Physically, they can also submit.
No, make your submissions properly. If you say physically, they will submit physically, then don't say that it must be submitted online.
They are not coming with true picture, my head. In fact, we file the response, the acknowledgement is also there.
What is your representation dated?
That is 28/6/24.
They made a categorical statement, they have not received it.
That we are, since that we got the information just now, so that document which we are having with us, I have placed with your worship. About the receipt, submission and receipt of that here. If necessary, to file against my hard copy, but it is there, already it is acknowledged also.
The standing counsel, revenue department is based on the instructions received from the department to submit that the representation dated 28/06/2024 stated to have been submitted by the petitioner was not received by the department, which however is disputed by the council, senior counsel by referring to where is that available?
That I have given, just now I have given.
In the no, we have given
It
it
is additional affidavit filed on 15/7/24,
additional application.
page 201.
BWD report.
page 201.
But this is lordship mailed to the PWD, not for the Revenue and Disaster Management Department. The mail ID. Lordship may peruse the mail ID. CSS PWD BNA.
CC.
So what is your internal page?
The internal page, it is not additional minus 4, 201.
Additional affidavit file, reply affidavit.
Yes, yes.
Reply affidavit.
Additional affidavit file on only additional affidavit.
That additional affidavit
affidavit.
filed on 15/7/24. Lordship.
Yes,
No, how did I get
201.
that?
It will be arbitrator or it will be.
Secretary.
PWD.
Tenga Kumbala.
There is one additional affidavit in reply filed on 19/6.
No, minor.
Now, this is only additional affidavit, Lordship.
This is simply additional affidavit. Page 178 and
Additional affidavit. It's on 16/11.
7/24. 15/7/24.
It is page number 201 in our copy.
Please below.
201 is part of the affidavit, not an annexure.
It's an additional affidavit, Lordship, filed on 15/7/2024.
Resolution minor. 201.
On the front page, it is written as additional affidavit, annexure 1, application dated 28/6/24, annexure 2, notice dated 8/7/20.
15/7, yes.
Yes, yes.
And page number, last but two. The internal page is not written here, but continuation 201 may be different from. But
201, yes.
Lordship may peruse the mail ID, Lordship. Two.
CCS, CSS, PWD.
PWD, not
This is
RDM. Lordship.
PWD.
No, man, it comes, she said, whenever it is, again, this comes, madam, from the special secretary.
What is your email address?
That is RDM, Lordship, but I can provide the mail ID to the petitioner, Lordship.
Mr.
Yes, we'll find out.
Chaudhary disputes something for the petitioner and refers to an extract of the receipts made available. Extract of the transcript showing the email sent by the counsel for the respondent. However, dispute that this email not the email prescribed for the competent authority, maybe the additional district. Which district is it?
Walpara.
Other, the email of the PWD authority. It is a, the provisions of the NH Highway Act. NH Act 1996 of section 3G5 provide that if any amount determined by the competent authority for the subsection 1 or 2 not acceptable either of the parties, the amount shall on an application by the arbitrator be appointed by the circular. For such circumstance, the petitioner will now approach the competent authority with the respondent number 5. Is it respondent 5?
9 months. I have filed making improvement
There is
And I has been filed
number
to,
six, number six.
no, I have filed to make him as a 9 mind. He is now 9 mind. Huh?
Who have you arranged as a party?
Chief Secretary.
Why will you file it before chief secretary? Under 3G5, you have to file it before the competent
Oh,
authority.
I has been filed making the special secretary at the responsibility.
It is to be filed by whom? Before whom? Who is the
Before-
Kala? Who is the Kala?
Kala competent authority there it is.
Okay, now arbitrator is the special secretary.
Special
Yes,
secretary.
special secretary.
Shall be filed before the special secretary. Number nine. Special secretary what? What is the designation? Special secretary?
To the government of Assam, Revenue and Disaster Management Department also.
Revenue and disaster management.
Oh, revenue department.
Revenue and
As an
Disaster
arbitrator
Revenue.
by the central government. Where is the notification?
Yes,
Notification is annexed. Lord.
I'm giving my,
It is also annexed with the additional affidavit, Lordship. Notification dated 21/02/2024. Also.
Page number.
page number,
Page number 9,
this is I'm giving.
additional affidavit filed by Asnal.
My duty.
Sorry, I. It was-
How about this one?
Notification dated 21st of February 2024. By the said notification, special secretary to government of Assam has been
Revenue.
appointed as the special secretary. Has been appointed as the arbitrator for the purposes of section 3G within bracket 5 for the districts mentioned therein, which includes Valpara. The writ petition therefore stands disposed of this state, directing the petitioner to file necessary application and provided for under section 3(5) before the special secretary, Government of Assam, Department of Revenue and Disaster Management. Stop. Upon such an application being filed, the arbitrator will decide, proceed to decide state application and pass necessary order. Any such order, any such speaking order that is passed, copies thereof shall be served on the writ petition. Is there any time limit?
No, family member, but the stay is there, man, because demolition.
The
Interim.
special, the arbitrator will dispose of the application within a period of 30 days from the date of receipt of the such application that will be filed by the petitioner under section 3G(5). Writ petition accordingly stands disposed of, remote or passed, will continue till such order passed by the arbitrator as directed.
Once it goes, everything will, demolition will come, man.
For a building lot.
No, no, because of the interim, they are going to demolish,
Assessment
man.
has been done by the competent.
So now see,
How?
what has happened is you are only, you are not objecting to the acquisition. You are objecting to the quantification of the compensation.
No, that is there,
So
man.
therefore, your quantification cannot be released to you unless the land is required, unless the land is used for the purpose. Why else will they deposit the amount?
No, deposit amount of the whole thing is, my lord.
You are not objecting to the acquisition.
No, I'm not, I cannot also, my lord, because it's for public purpose.
Whether you cannot
Now,
or not
since,
is
my lord, before determining amount, they cannot take it also, my lord.
No. Therefore, you are not challenging that acquisition.
No, I'm not challenging the acquisition because, my lord, your lordship, it say, TH2, my lord, say, as soon as after the amount has been deposited under subsections of competent authority shall, the central government, so on and so on. Until and unless I get my lord, that one,
You show us from the provisions that until and unless you
No,
get
the-
the amount, you are not
land
entitled to.
cannot be, that is not especially there, my lord, but just have a look to my lord, payment, 3H, my lord, 5,
Please read. Please read.
TH.
Yes.
Their part to be completed, then of course they can take over.
No, please read which provision.
My your lawyer, the amount determined under the section 3G shall be deposited. So their part that is to be completed by deposit, then they can take over, no problem.
Who is deposited, Lordship?
No,
No problem.
not deposited. My. Means it dispute come, my lord. As soon as maybe after the amount has been deposited under subsection, so complaint authority shall who will deposit money after arbitration.
Yes.
Land has already been acquired, Lordship. And they have not changed that
So
acquisition.
first,
Lordship.
there has to be a determination under 3G.
Yes, already determined. We have deposited the amount also
You have
to the Kala.
deposited, but now 3G5, there is a provision if they are not
Yes,
available.
let them, approach the arbitrator if they will
Right.
get Lordship,
Uh,
definitely we pay the
The
match amount.
matter
Lordship.
be decided within a period of 30 days from the date of receipt of the certified copy. Interim order passed will continue till the date such taking order is.
Lordship,
All
how
right,
much the
sir.
construction, Lordship, we have stopped that area,
That's
Lordship.
the provision of the act.
No, how they can Lordship, if they have approached the arbitrator will decide. If the arbitrator.
Kindly go through the provisions of 3H. 3H.
Yes, Lordship, but they have said the deposit and payment of amount. The amount determined under 3G shall be deposited by the central government in such a manner as the laid down by rules made in this behalf by the government with the competent authority before taking possession of the land. We have already deposited to the competent authority.
So that amount they're questioning.
That
Therefore,
question, they
the-
are not taking the amount, so let them approach the arbitrator. If the arbitrator is satisfied, then he will enhance. If he is asking the 5 crore rupees for the land, which
This
is
is our interpretation. If you are agree, you are free to go in a bit. That's all we can say.
they have, let them approach Lordship. Why interim order should continue? Why our construction work?
We deem it
should-
necessary that an interim order should continue till it is disposed of.
It will take some long time, Lordship.
30 days from the date of receipt.
30 days
You don't take long time.
time frame, Lordship.
30 days. How much time do you require? How soon
So
can
many
you do it?
pending cases, Lordship.
How soon do you want to do it? 1 week?
It's a matter of public interest, Lordship. What shall I
Is
say?
there a time frame, Lordship? It will be. a problem.
I'm not understanding your submission. What
Lordship,
is your problem?
Lordship,
Yes.
that our Lordship has indicated in the order that the representation may be disposed of within 30 days.
Yes.
Lordship. May not be possible, Lordship, because there are so many pending cases as per my knowledge.
So how much
Lordship.
time do you want?
3 months, Lordship.
3 months. So 3 months, there'll be an
How
interim order
can
for 3 months.
we stop the fight? Because other person already constructed the road, Lordship.
So what can be done? You then argue the matter, you agreed. When we heard the matter,
It's a matter of public interest, Lordship.
madam, you,
How they can stop the work
no,
of the
public interest is okay, but
It's a
public
project,
interest
Lord.
must be applied following the provisions of the law. The law,
Yes,
The-
if they are not satisfied with this 3H5, what says, Lordship?
then
If the
what,
amount determined by
what
the
meaning is to be ascribed to section
already
3H?
assessed, building
What,
amount.
kindly listen to the court.
Yes.
What meaning do you ascribe to the provisions of section 3H1?
3H1.
Yes.
That is, Lordship, the amount determined under the 3G shall be deposited by the central government in such a manner as may be laid down by rules made in this behalf by the government with the competent authority before taking possession of the land.
Correct.
Before taking possession of the
Now-
land, Lordship, we
Now,
have
where is the provision for approaching the arbitrator under which section?
3G5, Lordship.
3G.
Yes, 3G5, if the amount,
3G5 is a part of 3G.
3G, if they are not satisfied with the amount, Lordship, they may
Exactly.
approach the arbitrator. Arbitrator
That is
will
what they are
decide.
directed to do. But the provisions of section 3H is very categorical. The amount determined under 3G, which will include 3G5.
3G5, if 3G5, Lordship, if they are not satisfied with the amount.
That is what
But
they
they
are,
are.
that is what their
Yes,
case
let
is.
them approach, but the why interim order should continue?
Because of the provisions of section 3H.
If arbitrator may not satisfied or may be satisfied, Lordship. He may enhance or no,
We
he
have-
may not enhance the amount,
You
Lordship.
interpret it in a different manner. You tell us that 3H will exclude 3G5.
No,
Section 3H1.
it's not, but what happened, Lordship, when the assessment has been made by the competent authority, as per the assessment, Lordship, we have deposited the amount. And they have not challenged the assessment, Lordship.
Therefore, madam, we are inviting you to interpret 3H1 in a manner that it excludes 3G5. You show us from the provisions of
It
the
is
Act.
not exclusive. We have already deposited the
If it
amount.
doesn't exclude, then it includes 3G5 also.
Because
The section, the statutory provision is absolutely clear that the compensation determined under 3G. 3G5 is a part of 3G.
3G5 is a part of 3G lordship. It's not acceptable to either of the parties.
Huh.
To either of the parties lordship.
Yeah.
The amount shall on an application by either of the parties shall be determined by the arbitrator to be appointed by the central government. That the application should be decided by the arbitrator. If
Correct.
they are
Where is-
entitled
under
to
what
get
provision? Under what provision is the arbitrator to decide? Where is the provision for the arbitrator to decide?
under 3G5 lordship.
3G5?
Yes,
So are you submitting that 3G5 excludes?
it doesn't
The
exclude. How they can, because we have, as for 3H lordship, we have
That's the mandate
deposited
of
the amount.
That's the mandate of the section. Before
That-
taking possession, you have to determine the amount under 3G.
We have determined, Kala has
You have
already assessed the
determined, but
amount.
you have determined, but there is a provision if they're not
We
agreeable.
have determined, lordship, the Kala has to determine the
whatever
amount.
it is,
We have
but
to deposit the amount. We have already
you have
deposited the amount.
the amount, but
Yes.
they are not agreeable, and now the matter is to be decided by the
It is not
arbitration.
lordship. They may not, if they are claiming 5 crores,
You
whether they
show
are
us.
entitled to get the 5 crores
No,
lordship.
you show us, you argue the matter then. We had invited you to give an interpretation, you agreed that they may approach 3G, that was your submission, we have recorded it.
That is their turn lordship. If they are not satisfied, let them, if they are satisfied, then arbitrator will decide lordship.
We have passed the order,
Lordship, in the time frame,
30 days, because NH says it is a,
Yes, lordship.
Public
Supreme Court also says lordship in this judgment. Because the public interest is the paramount consideration, and the National Highway Authority can be said to be the best judge to decide which land to be acquired and which not to be
how is
acquired,
this applicable here?
lordship.
How is this applicable?
Next part, lordship. In view of the matter, no interference is called for in excessive powers under Article 136 of the Constitution of India.
How is that judgment applicable in the facts of the case? It is
Because
not a
it's
case of choice.
matter of public interest, lordship. How they can make fair, I
Public
don't
interest
understand.
Is okay, you
Because the
interpret
public
and
is
tell us
separate,
that public
lordship.
interest overrides the provisions of the statute. You argue that
Oh,
matter.
never overrides. I never said that, lordship. Let them, if arbitrator is satisfied, arbitrator may not satisfied,
Madam,
lordship,
you
then
are-
what will happen?
You are arguing a matter, but please argue and interpret the provisions of the act.
If lordship assessment, they are not satisfied, they have not challenged the assessment, lordship.
They are not required to. The provision under 3(5) gives them the opportunity to agitate before the
Yes,
arbitrator.
let him approach. Arbitrator
And
will
until
decide.
that is decided, there is no compensation decided under 3G. Until you complete the compensation under 3G, deposit the amount.
Deposit the
3H
amount.
says that you cannot take away the land.
Cannot be
That's the
taken.
interpretation.
Yes, lordship, we have deposited, then. Yes, lordship.
Lordship, I will clear, lordship, that time frame may be.
No, 30 days. If you want more time, you file application and get it extended. That's the liberty you have.
Fine.
Your counterpart is harping that it's a public interest, you're asking for more time. Yes, this both.
Yep, yep, like.
Infrastructure project, that's why.
IS, pending IS are also disposed. Yes. He wants to implead himself as a party.
Yes.
So
Lordship,
what-
my
what-
objection may be recorded, Lordship.
Your objections are recorded, but who are you?
My lord, we are the shareholders and general members of the society, my lord.
Why,
So
why the petition has been filed? What is your demand?
Lordship, the petitioner has challenged the order dated 10/10/23, Lordship, wherein the society has been dissolved and one-man committee has been appointed to manage the affairs of the society, Lordship. So at present, a one-man committee is running the society, Lordship.
Okay. Now, where is that order?
Lordship, order is at page 81, Lordship.
81.
Lordship.
What about the election?
Lordship, there is an interim order operating Lordship that is honorable court. Interim order dated, my lord, 17/11/2023, not to hold the interim order. Now, one-man committee is running the society. We have filed our affidavit in the main case, madam.
But why you have not filed a modification order? You don't want the election to be held as a department?
One-man committee is running, if the Lordship may
That's not
dispose
the
of
mandate
the,
of the act.
yes, Lordship may dispose of the whole matter, we have no issue, my lord. My lord may take up the whole issue.
So what is the whole issue?
But it petition, main writ petition, not the I,
Main writ petition is challenge the one-man committee.
yes.
Now, what is the one-man committee supposed to do? Where is the provision under the act to say?
Within 90 days, they have to
Then?
hold the election, but
Then?
since the interim order is operating, my
Interim
lord.
order is there because you have not asked for vacating, vacation.
Yes, that instruction I don't have, Lordship, that's why. I have filed my affidavit in the main case, my lord.
And what about the applicants? Who are you?
Hello, we are the shareholders and general members of the total, my lord, 43 members of that society. Out of 43 members, we are the member, my lord, general member.
Why do you want to get implemented?
My lord, we want to implement Joe one-man committee was appointed and it was not barred by this court also. But till date, at the interference of the, without the cooperation of the president and the secretary, till date, one-man committee did not take charge, my lord. One by one, one-man committee was appointed, but as the secretary of said society times and again replied that I have no record. So one-man committee did not take charge until date. That society is, my lord, paralyzed, my lord. That is our problem.
Yes,
So-
anything to submit?
Lordship, if this whole issue is with regard to the petitioner and the respondent authorities, Lordship.
So if, my lord, case is,
If
my lord,
they have
followed
something-
by directing.
if they have
the
some
general
grievance,
meeting
they
that
have-
we have no, only the
They may
general
approach the
meeting.
honorable court, Lordship.
We want a general meeting.
And who is the petitioner?
He was the president of this particular society, Lordship.
Then why have you prayed for interim order not to hold election?
Lordship, because the whole issue involved in this writ petition is that, Lordship, whether in the time frame the general meeting was held or not, Lordship, within the stipulated time frame the general meeting was held, Lordship. That is the issue to be decided, Lordship.
Heard I heard counsel for the applicant, also heard counsel for the petitioner as well as counsel state. This IA has been filed by the applicant to seek improvement in the writ petition WPC 6467 of 2023. The writ petition has been filed by the petitioner challenging the impugned order. Where is the order?
Page 81, Lordship. Then annexure is, Lordship.
This is the original, the type of 81.
Order dated 10th of October 2023.
Sure.
Whereby issued by the zonal joint registrar of cooperative society, appointing a departmental officer as a one-man committee to manage the affairs of the society and to hold the AGM/election within a period of 90 days from the date of issue of the order at the cost of the society. So, the petitioner claims to be the president
Lordship.
of the said society who was duly elected and therefore the impugned order passed by the joint zonal joint registrar of company cooperative society is contrary to the provisions of the act, and therefore he submits that the same should be interfered with, and he being elected democratically under the provisions of the act, he should be allowed to function as the president of the cooperative society. So this court, by order dated 17/11/2023, while was pleased to direct the interim that though the dissolution of the society is not stayed, no steps be taken to hold the AGM/election of the society in question till the next returnable date, and the society will be continued to be run by the one-man committee. So, pursuant to this order, the one-man committee has been functioning. It is required to run the society. So, there are present applicants have approached this court, submitted that they are also shareholders of the same society. And although the zonal joint registrar of the cooperative society has directed issuance of had appointed the one-man committee to run the society. However, till date, the one-man committee has not been able to take over the affairs of the cooperative society and run and manage the cooperative society in the absence of the relevant records being handed over by the secretary. By whom?
Yes, madam, but secretary said that no records in my hand, but secretary not said that the all records are in the hand of the president. Only that much he said.
That is their submission.
Yes, my lord.
That the records are not available. and
No,
therefore
that
the
is in
same
record,
not
my,
handed over to the one-man
it is
committee.
in the record, my lord,
So,
in my IA.
the further submission of the applicants is that they being shareholders, they are concerned with the welfare of the society, and therefore the one-man committee should proceed to hold the AGM as per the provision of the law, and accordingly, that's not being done. They are aggrieved, and therefore they are a necessary party and filing in seeking imprisonment. Senate Council for the petitioner and the opposite party has objected by filing necessary objection, raising the objection that they are not necessary parties, therefore their prayer for being impeded or not to be permitted. What about state? Any objection?
It's up to my lord's implement. I have
State council appearing for the corporation party object to the prayer made for impediment. Senate Council the party are the pleadings available in the IA are reduced. From the pleadings, it is seen that there is no dispute raised by the information that present applicants are shareholders. So it is also seen that pursuant to the orders passed by the zonal joint registrar of cooperative society appointing the one-man committee was required to take over and manage the cooperative society. The whole necessary election is required. However, by virtue of the interim order dated so although the dissolution of the society did not stay till the next returnable date, it was directed that the election or AGM not required to be held by the one-man committee. So it is also necessary to note that the submission of the applicant that they are shareholders and are concerned with the welfare of the cooperative society cannot be overlooked. The further submission of the applicant is that although the one-man committee has been directed to take over the functioning of the society, there he has not been able to take over the affairs of the society in the absence of records being handed over by the former secretary. So, in such circumstances, this court, such circumstances, this court cooperative society. You're not directors,
No, my lord.
shareholders of the cooperative society. They would indeed have an interest in society being properly managed, run. So under such circumstances, it's important that applicants ought to be arrayed as party responsibility. Petition numbers, so according to ISS allowed. Overruling the objection made by the petitioners when the applicants when are directed to be at respondent numbers when in the petition number. The applicant will file amended post title within a period of 1 week from today before the registry. Thereafter, the registry will make necessary endorsement in the petition and the same shall be listed thereafter.
My lord, I have a submission. Though we are including, if lordship take the whole writ petition, we are
The
submission
process-
to one lord to
Lordship,
hold the general
After
meeting.
next week,
Only
after 1 week.
My lord.
only.
Lord,
Hold the
okay.
general.
Lordship, interim order.
Interim order passed earlier.
Then, my lord, it may be directed to the petitioner to, my lord, facilitate.
Lordship, this is an implement petition, Lordship.
Now, already,
It is an implement
already.
We
petition,
have
Lordship.
directed you to file the amended post title. After that, the matter will be listed. Further orders will be passed thereafter.
I'll get.
Obliged, my
Obliged.
lord.
On last occasion, I was directed to produce the record, rather see whether any materials was collected after order of the division bench. Thereby, the inquiry was set aside, but lordship an liberty was given to the authority to continue with the investigation. This aspect of the matter was also dealt by the executing authority while passing the order. So this was a specific submission of the petition also. But to make first come to page 149. The order of the division bench.
Yes.
I am placing paragraph 7, 8, and 9. In order to verify the submission of Mr. Sharma, the London Standing Council for the appellant, we asked him to produce the statement of Chiranjeev Roy Chaudhary, Senior Vice President Technical Service of the respondent company, and in compliance of our direction, Mr. Sharma, by way of an affidavit, produce the statement of the said Mr. Roy Chaudhary. We have gone through the statement recorded by the investigating officer of the department. We are surprised that no such statement is stated by Mr. Sharma or informed him by Mr. Kumar Sarkar, the Assistant Commissioner, with regard to this information by Chandrakanta Sharma was recorded. The said Mr. Sharma, who was present in the court, was also asked to verify the veracity of the information with to this court through the Standing Council, and in fact he informed this court through the learned counsel that the said information was fed to him by the investigating officer, which is forwarded to the Standing Council. On perusal of the said information given to the learned counsel, Mr. Sharma, it is seen that the name of R.K. Sarkar of the Assistant Commissioner is very much reflected in the said instruction. The learned counsel as such, the misinformation to the court amounts to fraud played upon this court. Next, paragraph 8. Behind such backdrop, we are of the considered opinion that the inquiry so conducted was rightly caused by the learned single judge, inasmuch as the statement of Mr. Roy Chaudhary so recorded does not mention about any misinformation as submitted by Mr. Sharma. While expressing our mind to the learned counsel, Mr. Sharma, for the appellant, he on his part prayed to allow inquiry to be conducted under section 11(1) of the Act 1944 without recording the statement of Mr. Chandrakant Sharma, the director of the respondent company and key managerial persons, after modifying the judgment and order of the learned single judge. To his prayer, the learned senior counsel for the respondent has not only filed his agreed but also stated that the respondent company will not change the inquiry report on the ground of non-examination of Mr. Chandrakant Sharma. Then paragraph 9, in view of the aforesaid, we finally dispose of the appeal by allowing the department to conclude the inquiry without recording the statement of Mr. Chandrakant Sharma. As agreed, the respondent will not change the finding adverse if any of the inquiry report on the ground that Mr. Chandrakant Sharma was not given an opportunity in inquiry. So Lordship, although inquiry was not interfered, but liberty was granted to the department to proceed with the inquiry without recording the statement of Mr. Chandrakant Sharma. And accordingly, Lordship, the final order was passed.
No, that is what we wanted to know, that what materials have you got
No,
pursuant to the subsequent?
I take up the only materials collected during the trial that is available on the record. There was no further any materials is available on the record.
Then what remains there?
No, Lordship, because Lordship, that's why paragraph 9, page 149. I'm again reading paragraph 9. In view of the aforesaid, we finally dispose of the writ appeal by allowing the department to conclude the inquiry without recording the statement of sin. At page 375.
Three?
375. This during the hearing of the proceeding, it was submitted by the respondent with regard to order passed by the High Court. It was also placed with, recorded by the executing authority in his order, final order law. This is paragraph 9, page
So what do you
375.
make out of 7, 8 and 9?
Lordship,
So what is the
no,
effect
Lordship,
of paragraph 7, 8 and 9?
9 Lordship, ultimately 9 Lordship, division bench has directed department to continue with the proceeding without recording the statement. Even in the preceding paragraph, honorable division bench has come to conclusion that the proceeding, they are not interfering with the proceeding. But Lordship, however, that is, and that's why the final order was passed. The basis of the materials so collected.
So that is what we want to know. These materials must have come after the division bench order.
No, Lordship, but there is no materials collected thereafter.
Then,
The order was passed on the basis of materials so collected.
so giving you permission to conclude does not necessarily mean that you will conclude by proceeding against the department, against the petitioner.
No, Lordship, there was
It can mean that you conclude by dropping the proceeding.
no, Lordship, but in paragraph 9,
Uh,
there is a specific direction that we could not.
Conclude.
Yes, conclude the proceeding without recording the further statement of. In view of the
And,
aforesaid,
and
we
if,
finally
if
dispose
any
of.
adverse findings are there, that shall not be challenged on the ground of C.K. Sharma not being given an opportunity.
Allowing the department to conclude the inquiry without recording the statement.
Correct. To conclude does not mean that you have to conclude. You're not saying that. It may mean it may go both ways. Either
Yes.
way.
Lordship, that's why I'm placing the reasoning, discussion and finding of the executing authority at page 379. Merit order. Paragraph 14, page 379. The principle of natural justice having been complied with, the case is taken up for adjudication. I have carefully gone through the record of the case as well as the submission of the notice. I find that the said SCN was for short payment of excise, central excise duty, including additional duty of excise and NCCD, the amounting to rupees 27 crore 61 lakh 33,589. only by misdeclaring the fact regarding maximum operating speed of packing machine number so and so installed in the factory in violation of the provision of Rule 6, 7, and 9 of Pan Masala packing machine capacity determination and collection of duty. Paragraph 14.1. The packing machine number so and so became operational at the factory at the Industrial Street, Bhavnavedan, Guwahati with effect from 18/1/2014, declaring the maximum packing speed of the said machine as 750 pouches per minute. However, in their declaration dated 18/7/2014 and 11/12/2014, the said notice has declared the maximum packing speed as
When is
1000.
the order of the single judge earlier?
So that is it, page previous to that. Page
134.
Start from page 134. The long was been. Then we come to page 144, paragraph 25. Merit, paragraph 25 or not.
No, you read from para 18.
18.
Yeah.
Look, I am unable to subscribe to the contention advanced by Mr. Sharma that he issued that the issue before the appellate authority was only in respect of legality and validity of the order dated 27/11/2015 in respect of the one single declaration. No doubt, the challenge was in the context of the order dated 27/11/2015. But while examination the validity of the said order, the appellant authority has taken into consideration the machine of the rules mechanism of the rules and has interpreted the same in a manner which cannot be said to be applicable only in respect of the said order dated 27/11/2015, unless the aforesaid order is interfered with the department officers are obliged to follow the principle laid down. If one wing of the department is allowed to be at the crossroad permits to take view contrary to the one taken by the superior authority of another wing, the same apart from bringing it in uncertainty will lead to administrative chaos, and in process the industrial development will be a casualty. Paragraph 19. In Kamlakshi Finance Corporation Limited Supra, the Supreme Court had held that the disposing of the quasi-judicial issue, revenue officers are bound by the decision of the appellate authority. The principle of natural judicial discipline, the decision of the appellate authority, the principle of judicial discipline requires that the order of the higher appellate authority should be followed unreservedly by the subordinate authority. The mere fact that the order of the appellate authority is not acceptable to the department cannot furnish the ground for not following it unless its operation has been suspended by a competent court. It was observed that it is a statutory principle is not followed. The result will only undue harassment to SSC and chaos in administration of tax laws. 20. The view that has been taken also gained support from the judgment in Dinesh Pregnance Supra. In the said case, the division bench of the Rajasthan High Court of the Jodhpur had observed that when an alteration of the pouch packing machine, the superintendent technical has declared that the machine cannot pack at any condition at a speed of packing more than 700 pouches per minute, and on the contrary, at the speed of the packing more than 700 pouches per minute, and on the fifth of the declaration, the division bench refused to accept the extent of the department that the machine was having the capacity to produce 1,000 pouches per minute, notwithstanding fact that the petitioner therein had on his own declared the production speed of the packing machine up to 1,000 pouches per minute. Sri Ganesh Chandra Supra was in the context of summoning of the managing director of the company under section 14 of the Act for personal appearance after conducting search and seizure in his business house of the company and in the absence of any incident of the amounts that any particular fact or document which is material for the purpose of inquiry is in possession of the managing director. The court has observed that the authority issuing summons was more interested in personal appearance of the managing director than to apply his mind to the books of account. Documents seized in the course of search and seizure and the document produced thereafter to find out the amount quantum of excise duty evaded, if any. It was observed that the Central Excise Authority should not summon any person in exercise of power under section 15 of the Act in a mechanical manner. In as corporation supra, the court has recorded the finding that each and every detail which was called for by way of summon already existed with the respondent department. It having seized the same under seizure and that it was not even the case of the respondent that they were in possession of any information which would go to show that the petitioner had withheld any books or documents which were relevant and materials. In the backdrop of the aforesaid facts, it was observed by the court that the issuance of summons was only with purpose to create record or of having made an inquiry or for some other collateral cases. The director of the company is summoned. As it appears from the pleading that the affidavit as well as the admission of Mr. Sharma on the ground that he was instrumental in taking a decision for the replacement of CPU and that the inquiry will be visited on the touchstone of the section 9AA the Act. Reliance placed on section 9AA is wholly misconceived as section 9AA is on the subject of offences by the company and the same has to relevant for the purpose of inquiry in question. From the summons issued to him, it is clear that the summons
Where is that impugned order?
between
Impugned order here?
that is at page 285.
Who?
285. The long order lawsuit. And discussion and finding is it start from page 379.
Carry on.
Then discussion is at page 379.
Three seven nine.
379.
Yeah.
So we come to paragraph 14.3. Start from before the letter dated 12/6/2015 to the jurisdictional assistant commissioner of Central Excise intimating him the malfunctioning of the machine. The said notice has been operating the said machine with declared maximum packing speed of 1000 ppm above 751 ppm. From 16/6/2015 onward, the said notice declared the maximum packing speed as 750 ppm in form number 1 in respect of the said packing machine number so. I find that the timing of the change of the maximum speed is conspicuous.
Is the first order also there, which was set aside by the
Inquiry was challenged.
Huh?
Inquiry was challenged.
inquiry. There was no order passed.
What's the page 144 of the single judge order, paragraph 26. In view of the above discussion, I find that the considered opinion that the inquiry initiated against the petitioner company by letter the fact of the case ought not to be permitted to be continued, and therefore the inquiry initiated in relation to packing machine number so and so is quashed, and amount to be so and so has been
108. Earlier order.
against that appeal was also prepared.
Then what was the order of the appellate authority?
It is at page 1113. Hmm? Appellate order.
So essentially, single judge has set aside the
Yes, single judge set aside, but
inquiry. Then you went in appeal.
appeal
Appellate authority also held that justified.
yes, but let's see paragraph 9.
So we see that the date of the order of the leadership. But inquiry, whatever materials, if any materials are there,
No, that
including the statement of that
No.
gentleman.
there is no materials available after that. But Lordship, the final order was passed on the basis of direction given by the tribal to you can continue with the proceeding. However,
But subject to the other finding the division bench that is the rightly court set aside.
that is there, but Lordship, paragraph 9, on that basis, Lordship, final order was passed.
So first, the order was passed by the assessing officer. Against that, there was an appeal.
Yes,
Appellate authority reversed the finding.
Passed it.
Quashed it. That subsequently further required.
further inquiry was.
Again start.
Again, inquiry was.
On the basis of the same facts, they started the same inquiry in respect to the same period.
It was quashed by the
Single judge. Because Lordship may just look into middle para 9 of the single judge order at page 142.
Yes.
Is para 9, my lord.
Hmm.
I have considered the submission advanced by the learned counsel appearing or so and so. From the stand taken in the offended opposition of the respondents, it is clear that the respondents had not disputed the fact that the petitioner's company had changed and replaced the CPU interchangeably used to controller, and that the subject matter of the inquiry is manipulation of the machine in a fraudulent way. By doing so, the speed of the machine is lowered, which was resulting in a short payment of central excise duty. As a part of the inquiry, summons has been issued to the officers of the petition company who are either directly involved in the managing of the machine parts, such as the controller, and have consented to the declaration of the speed of the machine by the department which is less than the actual operating capacity machine. Rule 6.2 of the rules provides that when a declaration is made under, that is Rule 6.1, the Deputy Commissioner or Assistant Commissioner of Central Excise, as the case may be, may make such inquiry as may be necessary, including physical verification, and thereafter approve the declaration, including the declaration on regard to the maximum capacity at which the machine can be operated for packing of the notified goods at various retail sale prices, and consequently determine and pass order concerning the annual capacity of the production of the factory within 3 working days. The second proviso of section 6.2 provides that if the manufacturer does not receive the approval in respect of declaration within a period of 5 working days, the approval shall be deemed to have been granted
subject to modifications, if any, which the deputy commissioner or the assistant commissioner of central excise, as the case may communicate later on, but not later than 30 days from the date of the calling declaration. Therefore, the approval of the declaration is not automatic or routine, and therefore the declaration is approved. The authority can make necessary inquiry, including physical verification of the machine. The expression used in the subrule 6.2 is the maximum packing speed at which the machine is available. Factory can be operated for packing so and so. The declarations submitted by the petitioner were approved as and when the same were submitted. After the CPU was replaced, a non-commercial trial was conducted in presence of the department officer. According to the report submitted in the trial run, it has been found that the maximum packing speed of the machine was 630 pouches per minute for both so-and-so gram, 10 gram pouch, and accordingly by the auditory so-and-so, the assistant commissioner of central excise redetermined the machine maximum capacity in the slab of 301 to 750 pouches per minute. This position continued until order dated. So-and-so was passed by the assistant commissioner of central excise, holding the maximum speed of the machine to 750 pouches per minute above. While passing the aforesaid order, it was also noted that there was no good reason for physical verification of the machine to determine the maximum package speed at which it can be operated. The aforesaid order was set aside by the Commissioner of Appeals by order so-and-so on an appeal. Thereafter, my lord, the appellate order finding is there. While passing the said order, the appellate authority reached the finding that the provision section 6.6 of the rules do not bar a change in the parameter relating to the maximum speed, and that the provision does not put any precondition for a change in the parameters declared and approved. The appellate authority went on to say that no explanation also is needed for effecting a change in the parameters so long as the change is genuinely affected and is physically verified by the department officers nominated by the assistant commissioner. It was further held that all the declarations about the maximum speed of machine were on record and nothing was misdeclared. There was no concealment of any material facts when the physical trial was conducted, and the officers had carried out the verification by applying strict parameters. It was recorded that the chartered engineer, the engineer certificate, is an authentic document to verify the speed of the machine as discussed in paragraph 842 of the minutes of the tariff committee so and so. Thereafter, my lord, after discussion of the at para 15, thus a view has been taken by the appellate authority that it is permissible to change parameters relating to maximum speed and no explanation is needed for change of the parameters. Till date, the aforesaid decision and findings of the appellate authority has not been interfered with by any forum. It is not in dispute that the petitioner had paid excise duty thereafter, my lord. So these findings, on the basis of that, my lord, Narayan Singh has held that once the earlier findings of the assistant commissioner has been set aside by the appellate authority, you cannot again bypass the appellate authority order and come to again the same finding which was earlier set aside. Now these findings, whatever the Narayan Singh judge, had not been interfered with by the revision bench. It remains.
What interpretation to be given the penultimate paragraph?
My lord, the interpretation of that paragraph is that the dismissal undisposed of. For the satisfaction of the department, it has been said that you continue inquiry, but sometimes your lordship also does, for the satisfaction of the lawyers, my lord, they are disposed of instead of dismissal. So that is a dismissal, nothing. On the first part, when the revision bench said, my lord, that the inquiry was rightly set aside by the Narayan Singh judge, how, my lord, the subsequent part can, my lord, can overrule the earlier part? It was submitted by the department that let us complete the inquiry. The court said, okay, you complete. And we have been, my lord, undertaking that we will not challenge the finding on the ground that he was not examined. We are not challenging the finding on the ground that he was not examined. My lord, I prepared a written submission.
We will like to deliver it in court on.
Well, I think if the court, it will be difficult.
Difficult.
There are so many.
Right, heard learning council.
And other three cases, my lord, on the same basis, the penalty has been imposed on the officers of the department, of the company.
Yes.
Lordship, since my learned senior friend has submitted for written submission, I'll submit a very short synopsis Right tomorrow.
This does not imply.
No, I'll not annex any judgment, I'll on the basis of.
There is no judgment, but very, they will annex.
All right. Okay.
I'll get it to you.
Okay. This is the- Right. Yes.
Lordship, the respondents had prayed for time on the last day to bring on record certain documents relating to the title suit. No affidavit has been filed. That is because, my lord, incidentally, on 8th of July, the administrator of the bank suddenly passed away due to a heart attack. And the RBI is yet to appoint a new administrator, so the signing authority, without any guideline from the RBI, who will sign the affidavit?
We don't know. It's for the bank to decide.
My lord, I
Become functionless.
No, my lord, but then the other affidavits also and the wakalatnama was also filed by the administrator only. I have received instruction that
Administrator of what?
administrator of the bank. So the bank was on the verge of insolvency, because of which the RBI had appointed an administrator to handle the affairs relating to the bank. Now, my lord, this matter becomes more urgent since the bank is on the verge of insolvency. My
Madam,
money is
no-
also stuck there. The
no
land is
such-
also not being given to me.
No such,
No affidavit is
insolvency
also.
proceeding is going to happen anytime soon, my lord. There was some mishandling, and as a result, the RBI had to step in and suspend the board of directors. And that is for a temporary timing.
When was that?
This was in 2021, November 2021.
We are in
Years
24,
already.
middle of 24.
Pilot process for election, there was advertisements calling for directors and advertisements for elections where.
Which bank is this?
Industrial Cooperative Bank. Ma'am.
So when is your administrator likely to be appointed?
Next, I have received instruction that next week an appointment will be made, and thereafter, within a week or two, the new administrator will join.
That means, my lord, 3 weeks.
My lord, the sudden demise is beyond my control, my lord. And that was on 8th of July, my lord, just last week.
All right, we'll keep it for 2 weeks after. Let us-
A fixed date may be given, my lord, because the money is
This
stuck.
what we give you a date. It is heard of the submitted by the council of the bank that the administrator of the bank was appointed by the RBI, but he expired 8th of July. The process is on for appointment of a new administrator. Current council of the bank submitted that she had been instructed to inform the court that the administrator is likely to be appointed. Appointment order is likely to be issued within a week. And thereafter, in further week or 10 days, the new administrator is expected to join. Let P. Agarwal that this is the matter and the money deposited by the petitioner has not been released, nor the land
Land.
which was purchased by the petitioner
Right.
at auction has also been let the matter be posted on 6,
If it could be 7,
7. Have it on 8. 7, all right, 7.
no
It's on
problem.
7.
Like,
Yes.
Petitioner seek to move.
You're for the petitioner.
Lord, there are two applications, one by me, WPC
Item-
118.
In item 7, we are the petitioners, in item 6, we are the.
Item 6, my lord, I am the petitioner.
Yes.
My lord.
Now, what happened, if I can start,
Yes.
because from the point of time, my petition is earlier. Question involved is how long an order issued under the Disaster Management Act can wait for implementation. What happened here? The respondent, he did cut a hill by the side of my house. It was so cut that the authority, having inspected both the forest, geological soil conservation, and all other authorities, they found that it has posed a threat to the entire locality. Complaint was raised by. And then, after thorough investigation, passed the order. Authority passed an order under Disaster Management Act, asking him to take certain course to repair the damage. I'll just take your lordship to that order. Kindly come to Hmm? 52. My lord, annexer 15, page 52. Kindly come to this first. It was addressed to the divisional officer, South Bank Soil Conservation Division. After inspection, what they said, kindly see this. This was 15/12/2020. With reference to the subject cited above, I would like to state that I have visited the site of Mr. Vikas Agarwala. This is Mr. Vikas Agarwala, respondent, dated 11/12/2020, in company of Mr. So-and-so, Junior Engineer, South Bank Soil Conservation Division. During field visit, it was found that neither any technical guidance was taken from any department, nor any permission was obtained from concerning authority. While Sri Vikas Agarwala did the art cutting in his plot of at 8 Mile, Amerigug, 2 number Khanapara, Guwahati. Moreover, no any requisite precautionary measures were taken during cutting of the hill, as a result of which the upper ridge of the area become very vulnerable and prone to landslide, causing threat to the people living in and around at any point of time. Therefore, the protective measures to be taken up to stabilize the plot of land on the hill are as follows. Number one, no further earth cutting should be done in that area. 2. RCC retaining wall in the lower part of the plot adjacent to the road is suggested. Series of boulder masonry wall with RCC post along with cut portion of the hill is suggested. Earth filling carrying from outside should be done to maintain the slope of the plot from the upper ridge of the hill to the proposed retaining wall. All the earth exposed area to be covered up by geotextile mat so that soil particles would not be disturbed or detached. 6. Vegetative measures, example, planting of grass, shrubs, plants should be taken up in the earth filling area. Further, these protective measures are suggested only to stabilize the hill slope, which has been already disturbed, so that no further damage would happen to the lives and property in and around the area. Any kind of construction, building, either temporary or permanent, is not at all recommended till the stabilization of the hill slope of the land. This is for favorable consideration. This report was submitted.
Yes.
Then this was forwarded to the authority, and then kindly come to page 55. This is Deputy Commissioner's Office, Kamrup Metropolitan District Disasters Management Authority. Dated 7/01/2021 to Mr. Vikas Agarwal, the respondent here, regarding earth cutting on hilly area. With reference to the subject cited above, and as per the report received from the divisional officer, South Bank Soil Conservation, it is observed that no requisite precautionary measures were taken during cutting of hill. Hence, now it has become very conditioned that and prone to landslide and also posing threat to the people living in and around the area. Therefore, you are asked to take all the following necessary protective measures as suggested by the divisional officer, South Bank Soil Conservation Division, in order to stabilize the plot of land immediately before monsoon season, and submit the action taken report to this end. Without otherwise, action will be taken as per Disaster Management Act 2005 under section 30, subsection 2, 3, and section 41, subsection 1C. Number 1, no further earth cutting should be done in that area. 2, RCC retaining wall in the lower part of the one plot adjacent to the road is suggested. 3, series of boulder masonry wall with RCC post along the cut portion of the hill is suggested. 4, earth filling carrying from outside should be done to maintain the slope of the plot from the upper ridge of the hill to the proposed retaining wall. 5, all the earth exposed area to be covered up by geotextile mat so that soil particles would not be disturbed or detached. 6, vegetative measures, for example, planting of grass, shrubs, plants should be taken up in the earth cutting area. Further, these protective measures are suggested only to stabilize the hill slope, which has been already disturbed, so that no further damage would happen to the lives and property in and around the area. Any kind of construction of building, either temporary or permanent, is not at all recommended till the stabilization of the hill slope of the land. Matter may be treated as a disaster urgent. They mentioned it. It may be treated as disaster urgent. This was dated 7/1/2020. This, my lord, was repeated on several times. He didn't turn up. He didn't do anything. Page number 59, Lordship will kindly come to. Again, this 21/1/2021. Because when nothing was done, this was again informed to the office. They again found that they've addressed this letter.
The department did not take any action.
No, department has not taken any action. Therefore, ultimately, we have come before this honorable court that there should be either he can complete it, else the department is liable to act. They cannot just sit over the matter and remain satisfied that we have issued just the direction. And if the private respondent has not taken up those measures, repairing measures, then we have nothing to do. This is not the question. They have themselves mentioned that there are provisions in the Disaster Management Act. They have said that otherwise it will be taken under section 30, section 41, they can proceed. Now, my lord, here this direction was issued on 27/1/2021. Again, kindly just read for a moment, my lord. Addressed to the Vikas Agarwala regarding precautionary measures. This is the subject, preventing earth cutting in the hill area. Reference was given. With reference to the subject cited above and in regard to the hearing of both the parties, you have agreed to construct the boundary wall in order to stabilize the plot of land immediately before monsoon season, as per the suggestions provided by Soil Conservation Department. Therefore, in order to save the lives and properties of the petitioner, you are asked to start the construction work immediately by taking all the protective precautionary measures in supervision along with consultation with the Soil Conservation Department. The construction activity should be completed before monsoon season and submit the action taken report after compliance of the order. Otherwise, action will be taken as per Disaster Management Act 2005. This was 27/1/2020. This again went unheeded. Then again, I wrote to the Deputy Commissioner that, look, nothing has been done. Annexure 19, page 62, my application. Then now kindly come to page 65. These are the most relevant documents I am taking to your lordship. This was the letter issued from the office of the Deputy Commissioner, District Disaster Management Authority to the Circle Officer. Subject: action taken regarding public complaint of Sri Bodhan Chandra Bora, 8 Mile, Amerigo. I am the petitioner, Bodhan Chandra Bora. Office order reference was given on 27/1/2021. With reference to the subject cited above, I am to inform you that the complainant Sri Bodhan Chandra Bora, 8 Mile, Amerigo, has submitted a petition regarding non-compliance of the direction issued by this office for taking precautionary measures by Sri Vikas Agarwal, Hatigaon, Guwahati, for preventing the landslide as per the suggestions provided by Soil Conservation Department. As the rainy season has started, non-compliance of the directions may cause threat to the lives and property of the complainant and other households residing below the hilly slope due to landslide. In view of the above, you are requested to cause an inspection of the site immediately and inquire regarding non-compliance of the directions issued by this office under reference by the one, namely Vikas Agarwal, and submit action taken report to this office immediately. Matter may be treated as disaster urgent. Copy of the petition along with the reference was forwarded. It was by the Additional Deputy Commissioner. Now, kindly see at page 68. This was from the Deputy Commissioner, Chairman, District Disaster Management Authority, letter dated 25/6/2021. Action, subject: action taken regarding public complaint of Sri Bodhan Chandra Bora is so and so. In inviting a reference to this subject cited above, I am to inform you that a petition from Sri Bodhan Chandra Bora, 8 Mile, Amerigo, number 2, Khanapara, Vide, letter number Sasanchas, was received regarding a complaint against earth cutting on a hilly plot of Sri so-and-so. A joint verification of the site was carried out on 5th March 2020 by Field Officer DM with the officials of Soil Conservation, Forest Department, Fire and Emergency Services, and concerned lot mandal of number 2, Khanapara. It was found that the said plot bearing tag number 258, patta number 19, R8.01 area land owner Sri Vikas Agarwala was illegally cutting the trends and no technical precautionary measures were taken, and the cutting of the trends into the hill is in a vulnerable condition. In addition to the above, it is also informed that on scrutiny of records by Office of the Divisional Forest Officer, Kamrup East Division, Basistha, it is seen that there is no permission issued for excavation and removal of soil on the said plot of land by Sri Vikas Agarwala. Notice to immediately stop the earth cutting was issued from Office of the Circle Officer, Dispur Revenue Circle. A detailed report in this regard was sent with a letter number Sasansas dated 16/6/2020. The Soil Conservation Directorate, Assam, advised Sri Vikas Agarwala to immediate measures may be taken to stabilize steep hill slope with series sources, wire created boulder, retaining wall in lowermost part of the cutting area, and all the earth exposed area to be covered by geotextile mat so that soil particle could not be disturbed or detached. In the recent field visit on 3rd June 2021, it was seen no action has been taken by Sri Vikas Agarwal to stabilize this steep hill slope. The hill is still in a very vulnerable condition, which may come under the grip of landslide because cause damage to lives and property of people living in and around the area. Definite opinion was expressed. Was the situation after going to the site. In view of the above, I therefore request you to kindly consider the report under Disaster Management Act 2005, Section 30, subsection 2(3), 24, Section 34 CM, these sections. This was issued by the Circle Officer to the Deputy Commissioner, Disaster Management. And thereafter, I raised this issue before the police also. I filed that page 70, my application to the police officer, informing all that he has not done anything. Thereafter, nothing has been done. So ultimately, I had to approach this honorable court that these orders are in vain. Nothing has happened. He has just ignored it. Now, at this stage, I had to approach this honorable court with this writ petition. And this writ petition was filed on 25th of November 2021. This is now 2024. And here, my prayer was, kindly see the prayer at page 23. Writ in the nature of mandamus shall not be issued, directing the respondent authorities to get the protective measures mentioned in the order dated 24/9/2020, Annexure 14, 7/1/2020, Annexure 17, issued by the Additional Deputy Commissioner and CEO, DDMA, Kamrup Metro, and the order dated 19/7/2021, Annexure 22, issued by the District Development Commissioner, that is CEO, DDMA, Kamrup Metro, to the Jorabat Police Outpost, executed at their own instance, and to take punitive and penal action against the respondent number 7, and for defiance of the lawful order of the authorities, with a further direction to declare the hill as a designated area under the Assam Hill Land and Ecological Sites Protection and Management Act 2006, as well as the Disaster Management Act 2005, as prayed for, or any other appropriate direction that may be issued. This is my prayer. Here, the authorities submitted an affidavit. This affidavit was submitted by Deputy Commissioner, Additional Deputy Commissioner, CEO, District Disaster Management Authority. A lot of people will find it. It was filed on 6/10/2023. Page number 76. 75.
Additional evidence.
Well, no, this is an affidavit. This is an affidavit submitted by the Additional Deputy Commissioner, that is the CEO.
Respondent number 2.
Respondent number 2. Page 75 in my record, my lord.
What is the name of the?
He is Ajit Kumar Sharma.
Yes, 7th of October. Right?
Yes, so yes,
Yes.
maybe we have received on 6th of October.
Yes.
Now, So at paragraph 1, he says that I am the CEO, District Disaster Management Authority. Now kindly come to 3, paragraph 3. That by the instant repetition, the petitioner has sought for a direction directing the respondent authorities to get the protective measures as mentioned in order dated such issued by the additional district commissioner and CEO District Disaster Management Authority, Kamrup Metro, and order dated 19/7/2021 issued by the District Development Commissioner, CEO, DDMA, against the illegal art cutting by one, namely Sri Vikas Agora, which is adjacent to the petitioner's building, posing an imminent threat to life and properties. 4. That by the order dated 25/9/2023, the Honorable Court has directed to file an affidavit to bring on record as to whether the remedial measures as proposed earlier by the disaster management authorities had been implemented by the respondent number 7, that is Sri Vikas Agarwal, and if not, whether there is any need to do so at the point of time. Well, this order was issued by this Honorable Court in this petition. It was on 25/9/2023 to file an affidavit. Thereupon they have come up. 5. The deponent begs to state that in compliance of the order dated 25/9/2023 of the Honorable Court, a re-verification of the site was conducted by Soil Conservation Department and a report has been prepared. As per the report dated 3/10/2023 of the Soil Conservation Department, the site is still in vulnerable condition and there is high possibility of landslide which is posing a severe threat to residents next to the said plot of land owned by Sri Bodhan Chandra Bora, the petitioner. Report is annexed. 6. That the deponent begs to state that on the basis of the said report, respondent number 7, Sri Vikas Agarwal, was issued notice dated 3/10/2023, inter alia directed to complete the precautionary measures within 7 days, failing which he shall be penalized under section 51B of Disaster Management Act 2005. Copy annexed. 7. That it is stated that section 34 of Disaster Management Act 2005 empowers the district authority for assisting, protecting, and providing relief such as shelter, food, drinking water, healthcare, etc. to the community in the event of any threatening disaster situation occurs. The authority may control and restrict vehicular traffic as well as entry of persons to, from, and within the vulnerable or affected area. It may also require experts and consultants in the relevant field to advise and assist as it may deem necessary. In the present case, as a temporary measure, district administration can provide tarpaulin to cover the open part of the slope so that erosion can be prevented, for which requisition has been sought from Circle Officer, Dispur Revenue Circle. Again, in case if the petitioner wants to vacate the residence for safety purpose, district authority shall provide temporary shelter to the family or for a stipulated period of time. Any alternate arrangements are managed by the petition. 8. That the deponent further begs to state that the plot of land in question is a Myadi Patta land and the landowner has to take the precautionary measures suggested by the technical department, that is Soil Conservation Department, by letter dated 15/12/2020, which is already provided to the respondent number 7 for implementation. The measures are as follows. Those they have mentioned here. We have already read it in the earlier 1, 2, 3, 4, 5. Now, thereafter, page 79, my lord, the second para, the district authority shall provide all the necessary technical support for implementation of protective measures. However, implementation and cost involvement for the work shall be borne by the landowner. That was their opinion. They have not done it. They said that this is the situation. It is still in vulnerable position. We can provide temporary tarpaulins, but otherwise the residents can be shifted. But he has not come up. Costs should be, in that case, realized from him. That the deponent submits that paragraph 9.
Yeah.
Although there is a need of taking remedial measures as proposed by the Soil Conservation Department, respondent number 7 has not implemented the protective measures and hence notice dated 3/10/2023 was issued to him and directed to complete the precautionary measures within 7 days. He has ignored this also. He has ignored this also. Nothing was done. And then what happened? Yes, they have annexed those photographs also. Well, thereafter, when the matter was awaiting this disposal, the respondent then came up with the repetition challenging that this order, which was issued way back in 2020, cannot be implemented. This second repetition, that is here item number 6, no?
Challenging which order?
No, sound of petition to the. Now, kindly see their prayer. Read petition 118 of 2022. Why? Okay. No. WPC 6133 of 2023. He filed this petition in 2023, praying for at page 21. Let us see his prayer. Writ in the nature of mandamus and or any other writ shall not be issued directing the respondent authorities to set aside, modify the impugned letters and orders dated 24/9/2020. All these orders issued by Lord asking him to take those precautionary measures. These all letters 24/9/2020, 9/1/2020, 27/1/2021 issued by the Additional Deputy Commissioner and CEO GDMA Kamrup Metro to conduct a hearing and make an inspection of the site in presence of the petitioner and respondent number 9 thereafter pass appropriate orders to allow the petitioner to lay down the basement of the RCC retaining guard wall by digging trench to the required level. He wants a permission to lay down the basement of the RCC retaining wall. He has already been directed in 2020 itself. He admits that yes, these are the situations. To take appropriate measure to ensure safety of the building of the respondent number 9, which was constructed without following the prevailing guideline and without ensuring safety. This was his false allegation made that was rejected by the municipality when he raised this to before the municipality. To direct the respondent number 9 to take appropriate measure, I am the respondent number 9 here. To take appropriate measure for safety of his building under the relevant provision of law, I am always taking, otherwise I would have been by now gone down to the hill. Because now I am covering the whole area with tarpaulin and all, temporary. That's how in this incessant rain, a severe damage would have been done. The weather has been changing, but that is why I am worried, including those in the downhill area, people there. Now, he has come up with this petition in 2023 with a malafide intention to prevent the whole thing. This is his intention. Therefore, my responsible submission is the authority has the power. The respondent disaster management authority has the power to implement their orders, to take those measures, and they have admitted yes, cost can be realized from him, otherwise this can be punitive measures can be taken against him. Why not? The authority is sitting tight. He is delaying and avoiding the whole situation. 2020 order was passed, this is 2024. 2023 he filed this application when he found that this court has already taken the matter seriously, that you department, what are you doing? Give us report. Thereafter they submitted report, and again, then he came up with the petition just to thwart the move. This is the Lucas, the modus operandi. This is the modus operandi. And here, the recent report in his matter, that petition 6133, the authority filed an affidavit, soil conservation. Kindly see this also. This was filed on 15/7/2024 by respondent number 4, Director of Soil Conservation. Page number 88, my lord.
Yes.
By Sri Sandan Ranjan Das. This is
Yes.
the affidavit, yes. Now, they have supported the earlier orders issued in from paragraph 5 onwards. They have narrated that yes, those orders were issued. If I may read it, my lord, let us go through it. Paragraph 5, page 90. That with regard to the statements and averments made in paragraph 5, 6, 7, 8, 9, 10, 11, and 12 of the writ petition, the answering deponent begs to state that the same are matters of record and the answering deponent does not admit anything which are contrary to and or are inconsistent with the record of the case. The answering deponent further states that herein letter dated 24/9/2020, the respondent number 2, Additional Deputy Commissioner and Chief Executive Officer, District Disaster Management Authority, Kamrup Metropolitan District, had informed the petitioner that as per joint verification record, which is received from the respondent number 3, Circle Officer, Dispur Revenue Circle, it is observed that illegal earth cutting was done by the petitioner without taking any technical precautionary measures. Hence, it is presently in a vulnerable condition and is posing a threat to the people who are living in and around the area. Moreover, the petitioner was directed to take all the necessary protective measures as directed by the respondent number 3, Circle Officer, Dispur Revenue Circle, in consultation with Soil Conservation Department, in order to prevent further damage by stabilizing this steep hill top immediately and submit the action taken report to the Additional Deputy Commissioner and Chief Executive Officer, District Disaster Management Authority, Kamrup Metropolitan District. Otherwise, it was very clearly stated that as per subsection 2, 3 of section 30 and subsection 1C of section 41 of the Disaster Management Act 2005, necessary action will be taken against the petitioner. A copy of the letter is forwarded to so and so annexed. Then 6, Lord Timothy. With regard to the statements and averments made in paragraph 13 and 14 of the petition, the answering deportment states that on 15/12/2020, the respondent number 7, Range Officer, Guwahati Soil Conservation Range, as well as Junior Engineer, South Bank Soil Conservation Division, and had submitted the physical verification report to the District Divisional Officer, South Bank Soil Conservation Division. In the report dated 15/12/2020, it was very specifically stated that on 11/12/2020, the site of the petitioner was visited by the respondent number 7, Range Officer, Guwahati Soil Conservation Range, and Junior Engineer, South Bank Soil Conservation Division. And during their field visit, they found that neither any technical guidance was taken from any department nor any permission was obtained from the concerned authorities by the petitioner while doing earth cutting in his plot of land, which is located at 8 Mile, Amedigu, number 2, Khanapara, Guwahati. It was further stated in the report dated 15/12/2020 that no requisite precautionary measures were taken during the cutting of the hills. As a result, the upper ridge of the area became very vulnerable and prone to landslide, causing threat to the people living in and around at any point of time. Moreover, in the report dated 15/12/2020, the following protective measures were suggested to stabilize the plot of land. Number 1, further earth cutting. Then repeated those things, guidelines already issued. Page 93, my lord. After serial 1, 2, 3, 4, 5, 6, next para. It was very categorically stated, it was very categorically stated in the report dated 15/12/2020 that the protective measures are suggested only to stabilize the hill slope, which has been already disturbed, so that no further damage can happen to the lives and properties in and around the area. It was further specifically stated that any kind of building construction, either temporary or permanent, is not at all recommended till the stabilization of the land in the hill slope. Now we can skip over that part and kindly come to again, the same thing has been reported in paragraph 7 also, referring to the divisional South Bank that order issued earlier. Now, Lordship may kindly go to page 96, paragraph 8. That with regard to the statements and averments made in paragraph 18 of the writ petition, the answering deponent denies the same. It is specifically and categorically denied that the orders were passed by keeping the petitioner in absolute darkness. The answering deponent further states that the divisional officer, South Bank Soil Conservation Division, VD letter dated 10/11/2023, had directed the petitioner to contact the range officer, Guwahati Soil Conservation Range, for providing the necessary support and technical assistance for construction of the guard wall to stabilize the area for probable the landslide. So already those were there. He was informed that we are here, take guardians and go ahead. But he has totally neglected. Paragraph 10, my lord, 97, that the answering deponent states that under the facts and circumstances narrated herein above, it is expressly stated that the writ petitioner had failed to make out any case for invoking the extraordinary jurisdiction of the Honorable Court under Article 226. So they have denied and given those photographs, Lordship will find at page 102 onwards, they have also given those photographs. It shows that the entire hill slope ridge was cut. And whatever was there, some portion again has fallen down the last year on rain. So I had to take the measure myself because the right side house is mine and I had to cover it so that the water doesn't go down directly to the soil. This is how it is being now going on. Therefore, danger still looms large and the authority has not taken any concrete measure to get its order implemented, and the respondent number 7 there and the petitioner in the other petition here, he is just avoiding, and by filing this petition, he is trying to get rid of everything. On the other, he says that I should be granted permission to construct the wall, which has already been there. All these directions are already there. If he fails to do that, his intention not to carry out, then what is the remedy available for the authority or the people there? So kindly come to the law now. Disaster Management Act. Particularly. There you go. To not deny, no. Let me hear it down. 30. Section 34. Power and function of district authority in the event of any threatening disaster situation or disaster, for the purpose of assisting, protecting, or providing relief to the community in response to any threatening disaster situation or disaster, the district authority may give directions for the release and use of resources available with the Department of Government and the local authority. B, control and restrict vehicular traffic. All these are there. C, control and restrict the entry of any person into the movement within the department from. Kindly come to K, construct temporary bridges or other necessary structures and demolish structures which may be hazardous to public or aggravate the effects of the disaster. Then ensure the non-government organizations carry out their activities in an equitable and non-discriminatory manner. M, take such other steps as may be required or warranted to be taken in such a situation. So therefore, they issued these orders that this is the necessary requirement. But they have not done it. Now kindly come to section 41. This is a function of the local authority. It says, subject to the directions of the district authority, a local authority shall ensure that its officers and employees are trained for disaster management. There is a local authority, circle officer, the soil conservation, forest and all that, ensuring that resources relating to the disaster management are so maintained so as to readily available for use in the event of any threatening disaster situation. C, ensure all construction projects under it or within its jurisdiction conform to the standards and specifications laid down for prevention of disaster and mitigation by the national authority, state authority, or district authority. So district authority has already issued those directions, copy to the circle officer and other officers, soil conservation, forest and all, to see that this is implemented. Nothing has been done. Now, if at all it continues and they fail to do it, what is the provision of law regarding offences and penalties? Section 51. Offences and punishment for obstruction, etc. Whoever, word is whoever, without reasonable cause, obstructs any officer or employee of the central government or the state government or a person authorized by the national authority or state authority or district authority in the discharge of his functions under this act, or refuses to comply with any direction given by or on behalf of the central government or the state government or the national executive committee or the state executive committee or the district authority under this act, shall on conviction be punishable with imprisonment for a term which may extend to 1 year or with fine or with both. And if such obstruction or refusal to comply with direction results in loss of lives or imminent danger thereof, shall on conviction be punishable with imprisonment for a term which may extend to 2 years. This is penal provision. Now he has refused time and again. Therefore, the authority is now to proceed under section 51. Yes, 51. And the other measures which were suggested by it should be done at the behest of him by the authority itself, implementation by the authorities.
At his cost.
At his cost. Law is very clear. Law is very clear. And since he has refused, the orders time and again issued, given enough time, and he has come up with false pleas now again, then what is the option open? To take the penal provision into hand and file a case against him and prosecute him. But they cannot just keep their hands tight. They are not powerless. Law has given them enough power. And these situations are very serious. It relates to the lives and properties of the people.
Yeah.
Therefore, my full submission. The petition filed by the respondent deserves to be dismissed, and the authorities should be direct that you take the measures, precautionary measures yourself and proceed under section 51 and take necessary action. Where is my response submission? Subject to what? And the authorities here, they have submitted their affidavits supporting the case. Yes, situation still prevents, but he has not complied with our direction. This is the respondent, official respondent pleadings.
There are some judgments here. Look at the judgment.
Judgment is still not. What? Yeah. No. You have done it. Yes, my lord. About the money. Judgment. They raised the plea earlier. The court also, in one of the collateral bands, posed the question. Now, because here is, they might raise this also, that there was an agreement, therefore, Disaster Management Act will not come into play. In that context, one judgment has been placed.
They are in agreement that
What happened, my lord? Kindly see, I will just place this. My decision. When this nuisance was caused, overnight it was done, at night it was done. So next morning when we protested and issue was, all people took up the issue, he came and gave an undertaking, it is virtually undertaking. In the form of an agreement, they have written it. Kindly see at page 37. 37.
of your writ petition.
In my writ petition. This is a commitment given by him even. That is why in one of the orders the District Disaster Management Authority has referred to, that he agreed that he will construct it after hearing both the sides. He says this deed of agreement is made on Sunday 2/2/2020 between Sri Vikas Agrawal and Sri B.C. Bora, Badan Chandra Bora. I am here. Let so and so that Vasistha out. This is my residence. Second party, which expression shall include. Now kindly come to next page 38. And whereas the first party is the absolute owner of the plot of land measuring 3 kathas covered by dag number so and so, pata number so and so. And whereas the second party is the absolute owner of land building GMC so and so, so and so. And whereas, kindly mark, the first party intend to construct. It says the first party intend to construct a retaining side guard wall on the left side of the plot of the first party and on the right side of the second party. And as such, both the parties have entered into this agreement under the terms and conditions as specifically described here in below, terms and conditions. That the first party decided to cut his hill plot land in connection with his residential purpose, and as such he agreed with the second party to construct a RCC retaining guard wall in the left side of the land and building of the second party. The second party agrees on the ground that the RCC retaining guard wall should be constructed by the first party under the guide and supervision of an experienced building construction engineer. That the first party agrees that immediately after cutting off the land from the building side of the second party, the guard wall should be constructed as early as possible so that no any harm and damages causing or arising to the land.
Between both of you.
Hello?
It's an agreement between the parties.
Hello, it is virtually undertaking given to him, given by him, that I will construct all this, we will do all this, don't worry.
Undertaking given to you.
Sorry?
This is an undertaking given to you.
Yes, yes. So I said that you raise it first, so that damage will not be done. Now they say that since this is there, how can the authority act upon? Under disaster management. This is not the law. And it does not prevent in any way because he has not complied this undertaking also. He has not done anything. And danger looms large. Therefore, I said, and that this undertakings or this type of agreement, so-called agreement, has no value at all in the eye of law in such cases. The section 72 says very categorical. Here, section 72, Lordship, might kindly look for a moment of the act.
Yes.
The provisions of this act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or in any instrument having effect by virtue of any law other than this act. It rules out everything. A disaster is a disaster. You must approach it from that angle, and all these precautionary measures, protective measures must be initiated. Therefore, he took the plea earlier. Then that time, the collateral bench, learned court asked me this question, whether we can. In that context, I submitted the decision that this always can be done. This has no value. This is not an agreement as such, rather it is an undertaking given by him to me to satisfy that no, don't worry, I am taking all this, I am giving it in writing. But he didn't adhere to that also. Thereafter, he was issued so many orders by the authorities from 2022 till the other day, and he has just ignored it. Therefore, we have the clear provisions of law. My respectful submission, the petition deserves to be allowed, and direction should be accordingly issued. He says that I am here to do it.
Petition deserves to be allowed.
My petition.
Your petition.
Yes.
Two petitions. Which one?
There are two petitions. I should have already submitted. His petition is indeed a bogus one just to get rid of. He says that I have not been heard nothing, but it is denied by the authority. It was there. And one of the orders that I have placed, they have mentioned that he also agreed before the authority. Yes, I am doing it. Therefore, enough time has already passed. Lordship may kindly pass some orders so that the situation is brought to a condition where all can live peacefully.
Where is this area?
This 8 mile, it is going beyond, just beyond that, Ganesh Mandir, overbridge, my lord, side by the side Ganesh Mandir, in that 8 mile area.
Beyond the CRPF.
Beyond that CRPF. Just going over the bridge, there is now it has come this side the temple, Ganesh temple, that just thereafter that hill, that side left turn, that is it.
My lord, that my learners, the senior has only revealed the one side of the story, my lord. And here the actual facts are something different. And the lordship, I am very much concerned, madam, very much worried about my plot also, because it's a Miyadi Patta land, and my lord, value is very much high. If it will erode the collapse, definitely, my lord, that is my responsibility. But nothing was happening like this, my lord, as on today. First of all, I would like to draw your lordship's kind attention as regards to this construct, page 37 of my petition. That is the permission obtained by this, my lord, that opposite party for construction of the building, my lord.
Page 7.
My lord, page 37. Page 37 says, page 37 of my petition, that is the permission, my lord, obtained by from the GMT for construction of his building. And that permission was obtained in the year 2002. My lord, got it?
37.
37, my lord. My lord, you may kindly see on the subject one, the name, thereafter the subject one, on the ground and my lord first. The ground floor and permission has been granted for ground floor and my lord first floor. The 2 floors, only 2 floors. Therefore, my lordship may kindly see that the page 39, my lord, that I have annexed, my lord, the picture of the house which was constructed by this gentleman, my lord. On bottom, my lord, the snap of the bottom, lordship will find he has constructed, my lord, a 3-story building instead of 2, my lord. 3-story building. Yes, page 39. This, my lord, appears very apparently
three-story building he has constructed, my lord. And moreover, my lord, there is some GMD rules and notifications are there, my lord, because my lord, the prior to construction of this house, my lord, first of all, because they are admitting, they are saying that it is a my lord, landslide prone area. They will have to, my lord, construct a RCC guard wall for the purpose of, my lord, to protect their building. But nothing has been done by them. Well, sticking with the, the boundary of my plot, they have constructed the wall. At that moment, I was not possessing that land. They are not, without following the guideline of the GMDA, they have constructed. Their house is just sticking with the main road. And on back side, they will have to leave some space. Nothing has been followed. And violating them, instead of constructing 2-story, they have constructed a 3-story. After when and the building is constructed, the permission obtained in the year 2002, and building was constructed in the way back in 2022. But 2022 to 2023, he has not assumed anything that his building is located in a disaster, in a landslide prone area, or or it will collapse, or it may collapse. 2002 to 2023. The moment I intend to construction my residential house in my plot, that I have approached to him to make a discussion, because in the boundaries there is no any construction wall, no any RCC retaining guard wall. That's why I have approached, and he denied to construct any wall. And without constructing any wall, he is constructing his own building. Definitely, it is in violation of the norms of the GMD rules. And thereafter, both the parties has entered into an agreement. Even though he had denied for my security, I have agreed to pay the all the expenses for construction of the wall. And mutually, we have entered it. Just a little bit earlier, the learner senior says that this is an undertaken. But this is not an undertaken. This is an agreement, my lord, entered into by both the parties. The case is very simple, my lord. Why he is dragging this, dragging me before the honorable court, I do not understand, my lord. It is just, my lord will find on page 43 that the senior counsel has referred earlier. Page 43 and my lord, page 44, Lordship may kindly turn the next page. My lord, Lordship may kindly see the witnesses and the signature of both the party. Signature of the second party, signature of the first party. This is an agreement, my lord. We have entered into agreement, he has given his consent. And my lord, why we have entered into agreement and why it is, my lord, required to construct the wall? Because there is no any wall, no any RCC retaining guard wall as per requirement for safety of his building. That's why, my lord, he has allowed me to construct the wall. It is very much apparent, my lord. If already there, the wall is there, constructing of new wall, the question of constructing new wall does not arise at all. My lord will find on page 43, on bottom paragraph, that the first party agrees that immediately after cutting of the land from the building site of the second party, the guard wall should be constructed as early as possible, so that no any harm and damage causing or arising to the land of building of the second party. Because there was no any wall. Even though I have approached to him, he has denied. But for my lord, security, I have decided to construct the wall. On para 4, page 44, the first party agrees that he will bear all the responsibilities regarding the RCC retaining guard wall. It was not legible. Type copy was there. It is on page 41.
What about the reports?
My lord. Reports.
What about the reports given by the
My
authority?
lord, that reports means, my lord, that I'm coming to the report, my lord. That just, my lord, I want to just very briefly, my lord, explain the facts. Thereafter, my lord, after the moment I started, for my lord, it is, my lord, that I have called the engineers and the expert and all, for my lay down the basement of the wall. Cutting of the soil is, my lord, very much necessary. Otherwise, the basement cannot be laid down. The moment I started work, these persons have my lord, rushed to the police stations, make some, my lord, FIR that I am cutting soil without taking any permission, my lord, and my lord, like this. Thereafter, the police came to the my lord, place of occurrence. They have, in my lord, investigator matter thereafter submitted a report, my
Where
lord.
is your building permission?
My lord,
Where is
my,
it?
my lord, I have not constructed anything, my lord.
Then why are you cutting the land?
My lord, cutting the, as per the agreement to, my lord, construct the boundary wall. Because
Then
without,
why do you want to construct the boundary wall?
because this is my plot, my lord, I am intending, my lord, that for, my lord, to intending to construct a building
So you mean
in,
to say that for cutting the hill,
my lord.
an agreement is sufficient, no permission from the
No,
authority?
no, I'm not, I'm not cutting any hill.
Ah.
Already he has constructed, he did the, my lord,
But
his
you
house.
just mentioned that you are cutting the hill for preparing the, erecting the guard wall.
No, these are private plots, my lord. Only, my lord, this, the plots are, my lord, plots are, my lord, adjacent plot, my lord. It is not that his plot is, my lord, located on upwards and my one is downward. Already, my lord, the land, which says,
There is a report against you by the authority.
that's why, my lord, I am approaching, my lord, that,
No,
that
but
I'm.
you are approaching after 2 years.
No, my lord, I was make a response, but report, so far the report is concerned, I will explain, my lord, how, my lord, they, the authority, my lord, themselves restricting me. Lordship, just, I would like to draw your lordship's kind attention, because, my lord, in this particular plot of land, my lord, which I have been possessed, that is, as on today, the particular plot of land is in the same state as it was earlier, while he was constructing his building. He has constructed his building in the way back in 2002 to 2003. He has not done anything. He has not assumed.
Therefore, we are referring to the report.
Yes, my lord. The reports. That's why, my lord.
Are
And
very
I'm,
clear.
my lord.
Reports are very clear.
To be,
There is an evident danger.
my lord is correct, but I'm, my lord, very much confused because he is submitting the, my lord, the complaint.
It is the report of the authority.
That's what I'm saying, my lord. Why the from the what is the consequence from the where the my lord report has been emerged? That is just my lord, just I would like to explain. My lord, he is saying he has, my lord, submitted a complaint before the concerned authority that his building is, my lord, unsecured. That, my lord, he has not taken any precaution. It may collapse. That is in 2023, my lord. That I am, my lord, I have my lord, submit some application before the concerned authority that's violating the norms. And it is very much apparent because that there is no any, my lord, boundary wall, nothing like this. My lord, I am very much confused. The authorities, instead of, my lord, suggesting him or directing him to take so and so precautionary measure to protect your building, they are, my lord, saying, you, my lord, suggesting, my lord, some measures to me. And, my lord, the vital factor is that, my lord, they are, my lord, suggesting me to construct me the, my lord, RCC guard wall. And to be very honest, my lord, I have, for the purpose of constructing the RCC wall, I have, my lord, hired some expert. The moment I, my lord, hired experts, he has to do this, my lord, police. They are obstructing my ways. How can I, my lord, construct the wall? And very, my lord, is not it. Lordship, just to, my lord,
I am
kindly,
asking you about the report.
my lord, which
What do you have
report?
to say about the report?
My lord, report, my lord, they are suggesting me, my lord, that the major vital, my lord, two suggestions that not to cut the soil. That is, and my lord, RCC retaining guard wall. My lord, rest of the, my lord, some plantation and vegetarians, my lord, that is, my lord, everyone can do that. My lord, I would like to draw your lordship.
Perfect.
My lord, so far as the my lord report is concerned, my lord, that has been submitted by the Soil Conservation Department. They are alleging that, my lord, I am cutting, my lord, there is some cutting of hill. That is the allegation and funding. My lordship, may kindly turn the page 49 of my report, my lord, which 6133. Lordship, may kindly see this is, my lord, the subject action taken report. That, my lord, some
Page
of
number?
page number 49, my lord.
Okay.
49. It is addition to the additional magistrate. Kamrup. Action taken report. That is the, my lord, action taken by this, my lord, by the, my lord, police officials against the allegation that I am cutting him, my lord. May I, my lord, read the relevant lines? My lord, on the body, my lord, in their, on the second para, in their regards, a case has been registered.
This is issued by whom?
My lord, that is, my lord, that is officer in charge of, my lord, Bosishta police station, my lord. He has, my lord, make an inquiry, inspect the, my lord, the site, and thereafter, my lord, considering all those findings, this report has been submitted. Well, as per the report, it is very clearly, my lord, it has been stated that cutting of land is, my lord, taking place just prior to his visit, and thereafter he, my lord, his visit, and thereafter there is no any, there is no any soil cutting thereafter. So the, my lord, suggestions they have, my lord, suggested for my lord, that as per the report, they are saying that, my lord, some.
Let us hear the government rules for the government. Yeah.
My lord, yes, my lord, GMDA rule is, my lord, concerns because we have, my lord, GMDA. So far as the construction part is concerned, my lord, whether it, my lord, of some precautionary measures have been taken, my GMDA is a concern authority, my lord. We have made.
Where is your permission?
My lord, my permission, I have not applied for any permission.
Then why are you asking for GMDA?
GMDA for, I have submitted, my lord, that complaint before the GMDA authority. And my lord, that, my lord, they are constructing, violating, my lord, deviating from this, my lord, relevant norms. And so far as, my lord, safety of their precautionary measures, my lord, for safety of their building is concerned, my lord, that is on page, my lord, 66, my lord will file the complaint. And so far as their, my lord, safety of the building, so far as the construction part, that is the GMDA is the, my lord, authority. And my lord, so far as, my lord, and in their complaint, they are, my lord, saying that in the complaint submitted by this, my lord, the other side, before this, my lord, before the deputy commissioner, they are saying that as a result of cutting off his plot of land, there would be a possibility of heavy damage to my land and building, as there is no sufficient support from the other side of the land, and the possibility of heavy destruction, erosion may occur at any time during the rainfall, earthquake, etc. So basically, his grievance is that, my lord, because his allegation is that I am cutting, my lord, soil, as a consequence, his building may collapse. So deputy, my lord, the GMDA is the concerned authority to make an inquiry whether, my lord, they have followed.
No, but who has complained?
I have complained, my lord.
Why have you complained?
My lord, because he is, my lord, submitting.
How are you concerned? You are not building a house.
I'm not building a house.
Then?
Well, his grievance is that I'm cutting soil. That's why his building may collapse.
Therefore, you will complain against it.
No, because
how will the authority decide on this? Your complaint would be that yes, he is unauthorized. You have got this information. Is a different issue.
Yes, that is.
Or it causes it endangers your existence.
Well, existence because
there are procedures in the GMC,
because,
GMD authority act.
Because GMDA, I have submitted complaint before the commissioner of GMDA, GMC Corporation, because he has not taken the precautionary measure. As per the norms, he has not constructed
What
building.
Precautionary measure?
There
is no precautionary. Is given a permission, whether the building is as per permission or not, is to be inquired.
Yes, my lord. That inquiry has not been done, my lord.
So that inquiry, you follow the procedures laid down on the.
Well, I have, my lord,
merely filing a complaint is not enough. There are other procedures.
My lord, the complaint is, I have lodged a complaint, my lord, and that is his vital issue is there. That's why I'm, my lord, praying before lordship.
Vital issue, we are not failing to understand. You are not constructing the house. You are just
Yes.
cutting the land.
Yes.
Why are you cutting the land?
I'm not cutting the land, man.
Then who's cutting the land?
No, I'm not.
That's the report of the authorities, soil conservation and.
Yes, my lord. That's why, my lord, these reports
Circle
are,
officer.
the reports are, my lord, doubtful. My lord, because this,
So let
that
us
I
hear
have,
the government on this. Let us hear what the government has to say.
my lord, GMC is the concerned authority. So far as, my lord, this.
Who has given the report against you?
My lord, against you, that the soil conservation department.
Therefore, we want to hear them.
My lord. That another aspect is that, my lord, I have lodged a complaint. That is also an issue.
Complaint, you follow it up under the provisions of the act.
My lord, and I have filed a representation before. That's, my lord, that is.
Representation will be considered disposed of.
Let them, my lord, the GMD authority to cause an inquiry
So
whether.
why should we direct the GMDA to cause an inquiry unless the GMDA authority decides to look into the matter as per the provision of law? But before that, you have to explain there are reports here against you.
The reports are there, but the
Then
GMDA is
Why,
also.
why should that inquiry also not be directed against you in view of this report?
Yes, my lord,
Therefore, we
they
want to
can,
find
my
out.
lord, the GMDA can cause in my inquiry, an
Not
impartial
GMDA,
inquiry against
is
me
the
also.
disaster management, soil conservation, they've all given report.
But
that
they
they-
are, yes, my lord is correct, but that, so far as GMDA is concerned, as per my understanding, my lord, they are related to the natural calamities all.
MDA cannot force an inquiry against you because you never prayed for a building permission.
That's
You
why,
have,
my
you
lord.
have not applied for a building permission.
But, yes, my lord is correct.
Then
But the
what
other
is-
side has, my lord, violating the, my lord, without taking the precautionary measure as per GMDA norms, my
How are
lord,
you concerned?
they have,
How are you concerned?
because the other side has not taken any precautionary
How
measure.
are you concerned?
That's why,
Is
my
it a building, is your
Yes.
building
Yes,
facing imminent threat?
my lord.
Is your building facing imminent threat?
Yes, my lord. His report says, my lord, lordship
Is
kindly.
your building facing imminent threat?
Yes,
from-
my lord.
How?
Because
But you have not constructed, you have not applied for any
plus
building
his
permission.
other side, with all
Have you
respect,
applied for a permission?
no, my lord.
Then?
Because I am not constructing anything on my plan.
Exactly. So
it
there
is
is no
vacant.
question of threat from threat from him.
My-
How is there a threat?
Yes,
from-
yes, that is the fact, my lord. Now, he's saying in the my lord, complaint, before, which has been submitted by the deputy commissioner, my
You
lord.
take your seat, let us hear the department first. Yes.
Yes, I will take just, my
No, no,
lord.
you take your seat.
My-
We'll hear you later.
Madam, I am representing in item number 7, madam, respondent number 4.
Yes.
I have had my affidavit on 19/7/23.
What do you have to say?
My lord, my learned senior and my lord, whatever he has stated that is true, my lord. And we have in latest, my lord, my affidavit filed on item
You have
number
given, you have submitted a report to whom?
2 before the, my lord, district disaster management.
Who is for the disaster management? What steps have you taken? In which matter?
118. First,
118. What have you taken? What have you done?
uh, okay, okay. Can I please?
Yes. 78.
That para 7 has already been purchased.
So 70,
It petition 118.
118. Affidavit by?
Okay, number. Information.
Yes. Era?
Para 7, 8, 9.
No, but the question is, what steps have you taken?
After filing of the affidavit, my lord, I have said, they have, because they have filed also a petition other party. This petition as per para 9, second, what I would like to suggest my humble court, madam, my humble prayer, that initially they have, though they have tried to start cutting illegally without any permission, madam. For betterment of resolving the issue, my lord, can we suggest my humble court that some, if they apply proper, they have to apply according as per permission for if they want to construct a boundary wall, madam. The assisting for soil conservation as well as district administration, but major are to be taken, but practicalities are to be provided to them in respect of constructing the guard wall, madam, between their boundaries. Thereafter, on their supervision of technical experts, that both of them can with new permission from the authorities upon their
Who
application.
is the authority to grant the permission?
They have to apply for CMDA, my lord. Thereafter,
So where is GMDA? Where is GMDA?
I haven't allowed. Because it will be a first case and legal that pollution. So far as
No,
section
we
51
find
is
from the
concerned,
pleadings that you had issued notices and you had given a report that
yes,
these steps should
sir.
be taken.
Yes, that then we are admitting it.
Right.
We are admitting as per our.
But if they have not taken this stand, then you should have proceeded under the.
The concern is that he has also filed a case, my lord. So as they, my lord, so there is to stay order.
There is no interim order.
No order. For that reason, no coercive action has been taken. Otherwise, we have to file an FIR to take action against it. But that action will involve the petitioner concerned and the respondent might not take their result. I humble suggestion, if that exercise can be done, all the type of technical expertise and all this, existing departments might also. Or their protection of both the class of lands, because their boundary will have to be constructed at some point of time. Or otherwise, all
Noted.
these actions that can be taken under section 64, 34 is a temporary measure.
Very well. We want the counsel for GMDA.
That exercise can be done.
GMDA is a party here.
Party here, madam.
Party.
Party, madam.
Have they filed any affidavit?
No. They have not filed any. Okay.
No. Which authority is required to grant permission for art cutting?
That is what could happen.
GMD.
Forest lands, other departments are also required to move.
Forest, provided it is a forest land. Is it a forest land?
But forest solvent of disaster
So what
management is.
provision? And what provision you require permission?
Forest department.
Forest department is in respect of forest land.
Forest land.
Right? Yes. We'll have it on Tuesday, 23rd, subject to your convenience.
My lord, I may be out of station, lordship will take care of, my lord, my state will be here. My lord, here in Maharashtra submission, when the soil conservation is the department, and they have enquired, they have taken, what is the department? So others are not concerned here. They have GMDA, he has made GMDA party, just to have a
No, we
case.
wanted to find out whether any
Yes,
permission
yes,
is necessary from.
Yes,
That will be, because it's
Yes.
a private land.
and the other issues raised has no relevance here. Lordship has rightly pointed out.
All right.
All right.
Further hearing on 23rd. Please inform the GMDA council. And you get your instructions with regard to the art cutting, whether any permission or under what scheme is necessary.
Admittedly, nothing. He says that nothing. No function.
Art
Police
cut
has said,
to the part. It's on 23rd. For further hearing.
Right.
23rd July.
obliged.
May it please your lordship. Lordship, as per the court's direction on 15 June, July, lordship, we have filed our written submission today.
There is no direction. We just wanted to know whether you want to file.
They
You have
filed
filed.
it.
You have filed it.
Yes, your lordship.
Right. Then you allow us to go through it. We'll also take it up on 23rd and pass a note.
23rd.
You have filed your objection?
My lord, yes.
Learned counsel to the parties have filed their list for orders on 23rd.
Obliged.
Obliged.